Ms. Karen Dongo, did you need to speak to your client at all before I call the case?
No, Your Honor, I've met with her multiple times. I saw her this morning too.
Okay, very good. Calling People versus Kelli Bryant, case number 250216FY.
Good afternoon, Your Honor. Kanika Ferenczi on behalf of the people.
And good afternoon, Your Honor. Cecilia Karen Dongo, I'm here on behalf and with Kelli Bryant, Your Honor. She's present from the Oakland County Jail via Zoom. We have no objection to Zoom.
Ms. Bryant, can you state your name for the record, please?
Kelli Bryant.
Is that Ms. Bryant's hand in front of her face right now?
Oh, that's
Okay, thank you. This is the time and date set for a probable cause conference on the 3 counts of first-degree child abuse. Ms. Karen Dongo, how did you want to proceed?
Your Honor, I've had extensive conversations with Ms. Bryant as well as with Ms. Ferenczi. At this time, I'm in receipt of, I want to call it partial discovery. I have the written initial police report, which is, there's apparently a supplement that will be available for me today. And also I have the children's interviews. I was provided with those yesterday. I don't have anything else. There are terabytes of electronic discovery that is going to be provided to me on the external hard drive that I provided to the prosecutor's office. So we're asking you to adjourn the probable cause conference so we can have all the discovery. I think it's paramount in this case, Your Honor.
And you discussed the 21 days with Ms. Bryant.
I did, Your Honor. She understands that she has a right to have her preliminary examination within 21 days. It's impossible in this case if we're going to provide her with effective assistance of counsel, and I think she understands and appreciates that. Our next court date would be set outside of that. She's not waiving her right to the preliminary examination just to have it, I guess, at this time within the next week, and she's in agreement, Your Honor.
All right, thank you. I will note that the 21 days is waived, not the right to the exam, but the right to have it within 21 days. I understand that there are still discovery issues pending. Before we get to the date, defense did file a couple of motions, and I will deal with those this afternoon as well. One was a motion to restrain pretrial publicity. I did receive and review the motion as well as the briefs. Any comment from either side as to that?
Your Honor, just ever so briefly in response to some of the things that the people were putting in their response or their objection to my motion, you know, there's a lot of information that's already public information, meaning the court proceedings are open to anyone, certainly to the media. There's the register of actions that are public. There's a lot of public information. There's also already a lot of information that's been disseminated via social media and the Oakland County Prosecutor's Office. The issue I'm having is that the Oakland County Prosecutor's Office disseminated information that really is confidential information that they have had me sign a protective order for before I could receive it, which included the children's interview. They also requested initially that I sign an agreement to not disseminate anything of discovery nature to anyone, including my client, and I declined to sign that. But so they've asked me basically to not talk about this case or share it with anyone, but at the same time it's saying that this is in the public interest. I don't think it's in the public interest to disseminate evidence that hasn't been admitted into court, and I don't think it's in the children's interest to disseminate any of that. The public can certainly be kept informed via the media when we have court proceedings, as well as, you know, what the public can look up on the public register of actions from court. So I don't see any public interest in the prosecutor's office continuing to hold press conferences and talk about this case, and, you know, including the Oakland County Sheriff's Office, which, you know, many of those deputies and detectives are assigned to this case. They're witnesses in this case, and the Oakland County Sheriff's Office continue to talk to the public about this case. I was especially disturbed by the fact that what looks to be body cam from one of the deputies that were in the home has been disseminated all over social media before we've even had any kind of court proceeding. So I do think it's a proper motion. I'm asking that you grant it.
All right, Ms. Ferenczi.
Thank you, Your Honor. I do just want to respond briefly to both Ms. Karen Dongo's statements today and also her motion. I do want to be clear. Oakland County Prosecutor Karen McDonald held one press conference on February 19, 2025, after Ms. Bryant was formally charged. In that press conference, Prosecutor McDonald combined her statements to the already public information switched from the square to that morning. Prosecutor McDonald has not made any public statements about this case that has any potential to deny Ms. Bryant her constitutional rights. The statement about the video, I am not aware of what video Ms. Donald is speaking of. From my understanding, we live in a social media era right now, and information and misinformation spreads very quickly. We did get reports that individuals in our community, not part of law enforcement, made unauthorized entry of the residence at issue in this case, and did record videos, take photographs, and posted their findings on social media that did have high views. And Your Honor, that vigilante activity does create a dangerous precedent and the potential of widespread distribution of misinformation. And Your Honor, I do believe that a gag order would prevent the prosecutor the ability to correct any sort of misinformation. This case has drawn a lot of public outcry, and a lot of that public outcry predated law enforcement's presentation of this case to the Oakland County Prosecutor's Office requesting charges. And the reason of that outcry is because the welfare of our community's children is a vital social concern. And the facts of this case squarely involve allegations of egregious harm to children. Prosecutor McDonald has a duty to comply with the Michigan Rules of Professional Conduct. MRPC 3.6 and 3.8 expressly recognize that the public has an interest in and a right to know about cases as such. The prosecutor was acting within her authority and in good faith in making already public statements during the February 19th press conference. The issues that Ms. Dongo brings up about this misinformation is the sole reason why it is important for the prosecutor's office to be able to check the misinformation and provide accurate information of what is happening in this case. The public has a right to be precisely and accurately informed about its vital social interests in the systems that are responsible for keeping our children safe, Your Honor. And I respectfully request on behalf of the victims and the citizens of Oakland County that the court deny the defendant's motion, Your Honor. Thank you.
As I indicated, I did review both the motion and the briefs that were attached. And the court did review MCR 8.116D1 to evaluate whether a restriction on information or a gag order prohibiting discussion of the case with the media, whether that would be appropriate. And as you're all aware, the Michigan Court of Appeals has indicated that an overbroad or vague gag order constitutes a prior restraint on freedom of speech, freedom of expression, and freedom of the press. So this court would have to determine that the interest to be protected outweighs the right of access. Denial of access would have to be narrowly tailored to accommodate the interest to be protected, listing the specific reasons for limiting access. The initial charges against the defendant have already been presented. The prosecutor has held a press conference, which was prior to the date of the arraignment. We are now at the probable cause stage, so it would appear that there should be no further need for such similar press conferences during the pendency of the case. A gag order, in this court's opinion, would be inconsistent with law, Michigan Rules of Professional Conduct, and the public interest. The Michigan Rules of Professional Conduct do provide guidance in this area, and those rules do permit a prosecutor to make statements that are necessary to inform the public of the nature and extent of the prosecutor's action and that serve a legitimate law enforcement purpose. The February 19th press conference that was referenced in the motion and the response was actually prior to the arraignment, which was February 20th. Now, massive, pervasive, and prejudicial publicity has been ruled in cases to interfere with an individual's right to a fair trial, but the mere existence of pretrial publicity does not automatically deprive the defendant or the prosecution of a fair trial. There are court rules and jury instructions that can provide protection in these areas. So while this court will not be imposing a gag order, I'm simply instructing the parties to comply with Michigan Rules of Professional Conduct and court rules during the pendency of this case. But should there come a point, while this case is within the jurisdiction of the district court, where there's a massive, pervasive, and prejudicial round of publicity, this court will review the issue and make the appropriate determination at that time. At present, defendant's motion to restrain pretrial publicity is denied. Now, the defendant has been charged with 3 counts of first-degree child abuse, which carries a maximum penalty of life. The defendant is still, however, presumed innocent until proven guilty, and that brings us to defendant's next motion, which was a motion for reasonable bond. I did, for the record, have a brief bench conference with both attorneys as to that motion. And the court is willing to do an evaluation of appropriate pretrial release conditions. The things that the court has to consider is the defendant's prior criminal record, if any record of appearance or non-appearance or flight to avoid prosecution, any history of substance abuse or addiction, the defendant's mental condition, including character and reputation for being dangerous, the seriousness of the offense charged and the probability of conviction and likely sentence, any employment history, status, and financial history as they relate to the ability to post bail, the availability of a responsible member or members of the community who would vouch for and monitor the defendant if released, ties to the community, including family ties and relationships, and the length of residence, and any other facts bearing on the appearance or danger to the public. So the standard at this point is not abuse of discretion, but the court is willing to review the issues related to pretrial release in detail. We would not be able to do that today because of the other cases that are scheduled. However, if both parties are available, I am willing to do that on Friday so we don't have an unnecessary delay. I do understand that we will have to adjourn the probable cause conference. Will this Friday at noon work for both parties?
Yes, Your Honor.
Yes, Your Honor.
That will be at noon, and that will be the motion for a reasonable bond, where the court will review it and make specific findings as to that. In the meantime, I've noted the 21 days is waived. We'll set the adjourned probable cause conference to Tuesday, April 15th. That will be at 2 p.m. For today's purposes, bond will be continued, but I will address it on Friday.
Thank you, Your Honor.
All right, anything else for the record on this case today?
Your Honor, will the motion hearing be held via Zoom?
It will be via Zoom, yes.
Thank you.
All right.
Thank you.
Thank you. You're all set. Bond is continued for today. Thank you. People versus Kelli Bryant, case number 250216FY.
Good afternoon, Your Honor. Kanika Ferenczi on behalf of the people.
And good afternoon, Your Honor. Cecilia Carantago up here on behalf and with Kelli Bryant. She is present from the Oakland County Jail on Zoom, and we have no objection to Zoom, Your Honor.
Thank you, Ms. Bryant. Would you state your name for the record, please?
Kelli Bryant.
Thank you. This is the time and date set that the court scheduled for defendant's motion to modify the bond and for a reasonable bond. Ms. Carantago, you did submit a supplemental pleading, and just to clarify, it references a letter to the court. There was only one letter that you submitted, correct?
Your Honor, this morning, so I obtained a letter from a community support that was sent in a separate email to the court, not into the court file. And then there was also a letter in regards to the medical condition that my client has that was set separate. So there should be one handwritten. Okay, perfect. Yeah. All right. Yep. Okay.
Ms. Ferenczi,
yep, there was just the one.
Ms. Ferenczi, you received those as well?
Yes, Your Honor. I received all those documents this morning.
At this point, the court is prepared to review the items that I had mentioned on the prior date, which were those things that I will address or attempt to address, the factors to determine which pretrial release option is appropriate and under what terms and conditions. I had indicated on the prior date, I'm looking at the defendant's, if any, prior criminal record, any record of appearance or non-appearance, any history of substance abuse, mental condition, the seriousness of the offense charged, the employment history, any financial history as it relates to ability to post bail, the availability of a responsible member or members of the community who would vouch for and monitor the defendant, any facts showing community ties, family relationships, also the length of residence, and any other factors bearing on the risk of appearance or danger to the public. Ms. Kirandando, anything you wanted to add that the court did not already have at arraignment?
Well, at arraignment, I think pretrial services verified Ms. Bryant's information, but quite frankly, many of the things that were put in the motion and the supplement that was added information. I think the court was somewhat concerned about being able to verify the information. I attempted to do that. In the supplement I submitted to the court, I listed all of those factors that the court just mentioned on the record and listed, I guess what's favorable to my client and what's not, and also how that information was verified. So if the court would like me to, I can go through, those factors. Again, as I had mentioned before, both at arraignment and I think also in the first written motion and then in my supplement, I think for Ms. Bryant, we all know the court can't deny bond, so I think everybody's agreeing with that. And then it comes down to whether, essentially a cash bond is appropriate at all, or if it should be a recognizance bond with some type of conditions. And I know the people, will argue that it should be a cash bond. My position is that the only time that the court could do a cash bond is if the court finds either that she's a flight risk or that she poses a danger to the community at large. If the court would like me to, I can go through all the factors that I mentioned and information.
Let me interrupt you, Ms. Kirandando, because one of the main things that was of concern at arraignment was the lack of a stable address for Ms. Bryant. That was one of the things that was the focus of the arraigning judge.
That's correct, Your Honor. And Ms. Bryant has a stable residence. She had a stable residence before that, her arrest as well. Now, of course, there's additional concerns because of the publicity that this particular case has received. So Ms. Bryant would not, and I did provide also, I think prior to the last court hearing, the court with the address, and I indicated also who resides at that address for the court. I'm very concerned about putting any of that on the record, given the kind of posture of this case. But that is with a family member who has also lifelong ties to the community. So Ms. Bryant does have a stable residence to go to. I have also spoken, to other family members, and I spoke to the person who provided a letter to the court, who is also a pillar of the community. Every one of them are willing to, to supervise and I shouldn't say, vouch, but make sure that Ms. Bryant gets to court. And I think, a tether could also assure all of that. The court would be aware 24/7 where Ms. Bryant is. So she was not transient. I know the previous judge made some statements that Ms. Bryant was transient. She was absolutely not transient. She was staying at a residence and had stayed there for quite some time. That is not a residence given the circumstances as they are right now that she would be returning to, and that is mainly due to the amount of publicity that this case has received. So of course now there's new concerns, but she absolutely does have a residence to return to. And I don't believe she was ever transient, Your Honor.
All right.
And I don't think there was any evidence of that either, quite frankly.
All right. As to residence, Ms. Ferenczi, is there any comment?
Yes, Your Honor, I would like to address residency, and then because I only received the supplemental motion this morning, I would like to respond to much of what was documented in that motion, Your Honor.
Okay.
But in regards to residence, what the people find troubling is that the individual that the defendant is being asked to be released to and reside with isn't the one that wrote the letter. That individual is not vouching for her, and I don't believe that individual has appeared in court and is willing to provide that voucher to the court. That is a concern, and it actually speaks to the high level of instability for Ms. Bryant. A lot of the statements about her transient nature is in conflict with what she told police when she was interviewed. So I do find it troubling when the information is, at times it feels like it's self-serving for Ms. Bryant. I'm happy to address the other issues though, Your Honor, in the supplemental motion.
Your Honor, may I address that particular point that Ms. Carency is making? So I will just tell the court, as an officer of the court, I've spoken to many of Ms. Bryant's family members. And here's the reality of things. The children, I think everybody has now known where the children are. And so the children are with family. And so it becomes a very difficult balance as far as, supporting, sending letters. I had conversations with the individual whose address, was offered as a residence. And that individual wanted to talk to Ms. Bryant too. There are issues with setting up, phone accounts for the Oakland County Jail and actually establishing that communication, to be frank with the court. I spoke to that individual about a letter when she spoke to me, and again, this is, as an officer of the court, when she spoke to me, she was absolutely willing to provide that letter. But there was also just a very short amount of time in which to accomplish that, and she had requested to speak with Ms. Bryant first on the phone. And it's my understanding that there was no previous, account set up for that, and there was 2 days to do it. So that's the reality of it. So it has nothing to do with the person not being willing to vouch for her. That person indicated to me that she absolutely would supervise Ms. Bryant and make sure, that she comes to court. But again, and I think that's the concern for the court, is that the court would like someone to say they're going to make sure she comes. And that brings me to some other things I put in my motion, which I don't think the people are disputing, that this young lady,
Let me stop you for a moment, because on the issue of where she will be staying, the court needs to be convinced that this is a stable residence if there are any modifications to the bond where there's a potential that she could be released. I understand the nature of people being hesitant to come forward given the amount of publicity, but the court has to be convinced that Ms. Bryant would return to court and also that she will not be a danger. So go ahead, Ms. Carandano.
Yes, so in regards to the return to court, Your Honor, which goes to the flight risk portion of, the bond factors that the court can consider, Ms. Bryant has no criminal history. So there's no history of her, appearing or not appearing in court at all, which means she has no history of failing to appear. She, and this information was verified by pretrial services. In addition to that, Ms. Bryant, and this is in the police report, so I don't think this is something that will be disputed by the people. Ms. Bryant, when she was contacted, so she was contacted by the sheriff's department and the officer in charge of this case in regards to this case once the children had been located, and she paid for a Lyft ride to the Oakland County Sheriff's Office to turn herself in to talk to the officers. I've been in practice for a number of years now, and I don't think I've ever had a client who actually paid for a share ride to go turn themselves into the Oakland County Jail, and she did that.
So it might be simpler if I go through the issues that I don't believe are in dispute. One, the fact that Ms. Bryant turned herself in after being contacted. I don't believe that that is in dispute.
It's not, Your Honor.
That's correct, Your Honor. The only issue that I would argue that is in dispute, her ability to cooperate with law enforcement.
Understood. Let me finish going through the items that I'm looking at. There is not a prior criminal record.
We do not dispute that.
All right. There is no record of prior non-appearance or flight to avoid prosecution.
That's understood, yes.
So the issues that the court needs to hear about are, and the court is already aware of the seriousness of the offense charged, and that is certainly something the court will be taking into consideration in modifying any bond. But we have not heard regarding the employment status, financial history as it relates to an ability to post, ties to the community, ties to family members, and the residency is still an issue. So Ms. Kirandango, if you can address those matters.
Yes, Your Honor. So in regards to the personal circumstances, which I think addresses many of those, Ms. Bryant does have a mental health diagnosis. This is reflected in the police report, and I'll tell the court I did submit a subpoena for her records for CNS, which I noted in my supplement that that's where she was going. I gave the court the name of her case manager for treatment too. it's not enough time to get those records, but this was noted. I also believe it might have been noted in the pretrial services report.
It is.
Right now, I believe so, and that information was verified, I believe, by her father. So she wasn't receiving any medications, but she was receiving treatment. In regards to her physical health, which is one of the other considerations, I did provide the court with a letter that indicates a medical diagnosis for which she's supposed to be receiving infusions. The jail can't accommodate that. Ms. Bryant also was scheduled to have surgery, which that time has passed, but she has issues with which could be internal bleeding that was supposed to be addressed via surgery, and she hasn't been able to have that surgery. I again submitted a subpoena for those records. It's just simply not enough time for St. Joe's, but I did provide as much information as I could to the court on that. Ms. Bryant also, she is a lifelong resident of the city of Pontiac, which that was verified by pretrial services. I also believe that the community support letter that I provided to the court indicates that that person is a resident of the city of Pontiac and has known Ms. Bryant since she was 14 years old. Also, her information in regards to being a Pontiac resident was verified by her father through pretrial services. I don't think there's a dispute that Ms. Bryant has lived in the city of Pontiac her whole life. She went to school in the city of Pontiac, and she's never left the city of Pontiac. So that indicates that she has strong ties to the community. I also believe that both the community support letter and also pretrial services, as well as information in the police report, indicate that she has family in the area. Her parents are here. I also indicated to the court that she has siblings in the city of Pontiac. She again has community support, which is not family, but longtime family friend, who appears to be an upstanding member of the local community, who provided a letter to the court indicating that she was in support of Ms. Bryant. So she absolutely has community support. Again, it's a very difficult situation. So when I say community support, I want everybody to understand that, that shouldn't mean that, we should be worried about the children, because everybody has made the children a priority. So I just, want the court to know that. But Ms. Bryant absolutely does have a lot of support in the community. In regards to substance abuse, there's no history of substance abuse for Ms. Bryant that I'm aware. It was not noted in any of the reports, and she has not indicated to me that she had a history of substance abuse or substance use, even marijuana or alcohol. So I don't think that is something that should be of concern to the court. But again, if it was, the court could order her into testing to ensure that she's not, using any illegal substances. That's a pretty standard condition of bond. Ms. Bryant also submitted, in regards to income, pretrial services report did note her past history of employment. I noted in my supplement that she was also, prior to her incarceration, she was employed. She was paid through the state of Michigan. I could not obtain that information because it's confidential information, and it was something that was shared with me a few days ago. So I was not able to obtain verification, but Ms. Bryant did inform me of who the person at the state of Michigan that was responsible for her was, and she provided me with that name. Unfortunately, it's a very common name within the Department of Health and Human Services, so I was not able to obtain specific information. She does have a pay stub. It's at the residence she was at. I made contact with the person who resides there. They were trying to locate the paperwork for me, but they were not able to locate it as of yesterday evening at 9 p.m. But she was employed, taking home about $800 a month. So that was what she was making at the time she became incarcerated. That amount of money a month would still make her indigent, which she's already been found to be, which goes to her ability to post a monetary bond. Oakland County appointed her an attorney because she didn't have the funds to hire one. So I think, but she did have employment, which is also something that ties her to the community. I just think her employment would not be enough, to post a monetary bail. I don't believe there's any family members that have funds. Like I said, they're all caring for the children, and that's financially stressful too. Nobody has money to post bond for her. At this time, I don't believe. The employment history, what was disclosed to pretrial services, was verified. Again, it appears that her father verified that information for pretrial services. Some of the other employment that she had was also, verified through the family court case. There was discussions about that. I'm not entirely sure if Ms. Ferenczi was on there when that took place, but it is also information that's been provided to the Department of Health and Human Services. Now, the risk to the community, that's one of the factors the court must take into consideration as well. And again, the chance of her reappearing, I wanted to just address that briefly. The court could address that by placing her in a steel cuff tether that she can't remove from her leg. The court would be aware at all times where she is. If she failed to appear, the tether would indicate where she is. But again, Ms. Bryant turned herself in and actually was inquiring, and I think the people would agree as to the charges she was facing. She knew she was potentially facing serious charges. She's aware. I've met with her probably 10 times at this point. She knows what she's facing. I don't have any reason to believe she has nowhere else to go. So she's a Pontiac resident. She's been here her whole life, and I think if she wanted to flee the state or go somewhere, she'd have done that, already, I think, because she was, again, not apprehended.
So I'm going to allow the prosecutor to respond to what you have said so far, but I will change a couple of things or modify. You indicated that pretrial services had verified her employment. That's not what the report reflects. It reflects that the defendant reported she had been unemployed since August of 2024. Excuse me, no sources of income were reported. Prior to that, she indicated where she had been working for about a month. So I realize that you are saying you have not had an opportunity to get all of that confirmation, but that you have been seeking it. Ms. Ferenczi?
Thank you, Your Honor. Your Honor, as the court has already noted, the allegations and charges in this case are very serious. Defendant, as the court is well aware, is being charged with 3 counts of child abuse, first degree, and there is a very high likelihood of conviction. The people are happy to provide any facts or evidence if the court would like to hear it, and the initial guidelines call for significant jail time. Your Honor, as I already indicated, the people do not dispute that Ms. Bryant turned herself in and that she cooperated with law enforcement. But as the court is also aware, that does not equate any sort of assurances that she will appear in court. In regards to the mental health diagnoses and that she was being treated by CNS, there's no proof of a diagnosis, nor were any dates provided to confirm that this is accurate. The people at this point do not believe the defendant is a reliable source of information. She has a history of concealing and deceiving. That is what we have here, Your Honor. And without any sort of proof, I do not believe that the court can use that as accurate information. In regards to defendant's physical health, again, there was no verification of this medical condition. What was provided was a treatment plan from the clinic at Oakland County Jail. And it seems like she is receiving that treatment that is necessary at the clinic. The clinic deems is necessary. There was an additional allegation that the defendant needed transfusions and a possible procedure. Again, not supported by documentation. But Your Honor, regardless of that situation, I would be hard-pressed not to address the reason why we're here today. The reason we're here today is because defendant did not provide her own children, the victims here, with basic medical care, basic needs for years. And this irony of her condition right now is not lost on me. And it seems like she can and is being treated appropriately at the clinic at the county jail. Your Honor, in regards to Ms. Bryant's employment history, again, no proof was provided about her employment status. And as the court has already highlighted, the information that was provided has not been confirmed even with pretrial services. So again, the people do have a concern that defendant is not a reliable source of information. What the people can confirm is that Ms. Bryant abandoned her children, the victims in this case, in an unlivable residence where several rent payments lapsed. In regards to defendant's ties to the community, and the support alleged in the supplemental motion, upon information and belief, the statements that Ms. Bryant had made to the police are quite the opposite regarding her level of support. Again, she has a history of deceiving those who were attempting to support her for years. And it is difficult for me to imagine that all of her beliefs about her alleged support systems have completely changed within 2 weeks of her being in custody. And honestly, it does feel self-serving, Your Honor. The letter that was provided to strengthen her community support argument was not, again, as the court has already heard, was not from the individual who she is requesting to be released to and reside with. That individual in the letter wants to remain anonymous. How is that considered a voucher or a support for the defendant? In the letter, the individual does not make any statements about how they intend to assist the defendant if she were released, and when the last time they even spoke. That individual also admits that the defendant lied about the victim's whereabouts. They also stated the defendant knew that this individual was there if she needed help, but defendant never reached out. This is all very troubling to the people, and it is telling about the serious instability of defendant's support and her willingness to rely on that support. No one is willing to vouch for the defendant. Your Honor, in regards to defendant's potential flight risk, the people do believe the defendant is a potential flight risk with the level of local and national attention and her lack of community ties and stable housing. Most importantly, we believe that she does pose a danger to the community, specifically the victims who are members of the community, who she egregiously and intentionally neglected for years. One other point the people want to address is the risk of reoffending. The people do believe the risk of reoffending is high here. Again, in her own statements to the police, while she was cooperating with law enforcement, defendant was not accepting or acknowledging what she did, which places a high risk of reoffending. And Your Honor, our request has always remained the same. We are requesting a high cash bail, no cash surety, no 10% provision, Your Honor.
All right, thank you. Ms. Kirandongo, this is your burden to modify the bond at this point. So any comments that are not repeating what you've already said, but anything else in conclusion to your argument?
I will try not to repeat myself, Your Honor. I just wanted to say that in regards to the bond amount or the kind of bond, quite frankly, the court would be much more assured of Ms. Bryant's appearance if the court was to do a surety bond, because it would involve potentially a bail bondsman who would also, in addition to any other supervision the court would order, would also be supervising her whereabouts. So actually asking for a cash only bond, I think on behalf of the people, for me, would be less of assurance of her, if that's what they're going to argue, of her appearing. A cash surety bond, on the other hand, would involve another party being a bail bondsman. That all being said, Your Honor, I think I provided a lot of specificities in the information that I provided to the court. Reality of it is that you can't get this information in writing in 2 days. Nobody ever has that information when a person is being arraigned at, first arraignment date. Again, given the level of attention this case has received, it's been difficult. The person signed their name to the letter, so the court knows who this person is. And I think everybody can appreciate, given the level of attention this case has received, why people don't want to show up on screen here with all the cameras and the news. And, I don't think that that's anything that would be abnormal. That being said, I think if the court was to follow the bond statute, again, Ms. Bryant's bond, I don't believe should be a cash bond. It should be a recognizance bond with conditions, which as I indicated, could include a steel cuff tether, pretrial supervision, mental health treatment, drug screens. All of those things would assure her reappearance and would also assure that the court knows where she is. So I'm asking based on that, and I think, in regards to reoffending, we know who the complaining witnesses were. I don't believe there's any risk of reoffending. The children, again, would not be in Ms. Bryant's care.
All right, thank you. At this point, the court did set this for a separate hearing in order to review whether there should be a modification of the bond. And as I indicated, the party seeking the modification had the burden of going forward with this. So the real question for the court is there a substantial reason to modify the original bond as set? Now, the purpose of the bond and pretrial release conditions are to ensure the defendant's return to court and also the protection of the public and alleged victims in the case. The purpose of the bond is certainly not to punish. Even though this is an extremely high impact case, there is much interest in the outcome of this case and in the bond. But the law is very clear that with certain exceptions, a criminal defendant is entitled as a matter of constitutional right to have a reasonable bond or bail established for pretrial release. cash bond is permissible if the defendant's appearance or the protection of the public cannot otherwise be assured. The court recognizes that this bond review hearing was set in a fairly short period of time, and some of the information that I requested, according to defense counsel, could not be provided within this time. I'll also note that the principal charges in this case are felonies, but not strictly assaulted crimes under the court rule. At this point, I have reviewed all of the factors that the court is to take into consideration in determining the proper bail. The court has also reviewed the pretrial services report, and in that report, there was still a question as to the residence. However, for purposes of going forward, we will use the address that is listed on the complaint and also in the pretrial services report. In terms of the mental health concerns, the court will address that as a condition of bond. I am still not satisfied that the court can at this point say that there is a guarantee of a return to court. The defendant has not been a flight risk in the past. However, the potential penalty in this case is quite high given the nature of the charge. The protection of the public and the victims is also a concern, and I do share some of the concerns that were mentioned by the arraigning judge in terms of the defendant's potential to reach out to the alleged victims, the children in the case, to try to influence any testimony, and I'm going to deal with that issue. So I realize that there may be a need to do further review of the bond, but I do find that the court has an obligation to set a reasonable bond, and the current bond amounts to a denial of bond. So what I'm going to do is modify based on the information that we have that is verified. So I'm going to modify the bond in this case. I'm still requiring a cash bond for purposes of ensuring that the defendant returns to court to give further support to protection of the public and to prevent reoffending. But I'm going to reduce the bond to a $50,000 cash bond at this point with the following conditions. The defendant will be on pretrial services supervision. There's to be no alcohol or illegal drug use, no possession of a weapon, no assaultive conduct of any sort while this case is pending, no contact with any child under the age of 18, absolutely no contact with the alleged victims in this case. That means no contact at all, including no personal contact, phone calls, text messages, no reaching out to parties who have control of those children right now, no contact with them whatsoever. I am going to impose a home confinement electronic monitoring device. The defendant may not leave home except for medical emergencies, court appearances, court-ordered testing, and if employment can be verified, it is not verified at this point, then seeking and maintaining employment. But at this point, that has not been verified. So I don't want there to be any confusion in indicating that the defendant can go to and from work. We need verification first. Any other travel will require permission of the court. No return to the address of the alleged incident. No return to the address of the alleged victim. Any changes of address would have to be provided to the court within 24 hours. Those would be the modifications to the bond at this point. Any questions as to what the court is requiring? And I will note that Ms. Bryant, be aware that if you violate any condition of release, you would be subject to arrest without a warrant and may have your bond forfeited, revoked, new conditions imposed in addition to any other penalties if you are found in contempt of court. Any questions, Ms. Kirandongo, as to what the court is requiring?
Just a clarification, so that's still no surety?
Correct. Ms. Ferenczi, any questions?
No, Your Honor, thank you.
And if, Ms. Kirandongo, as further information is received, I know you have subpoenaed some information, you can provide that to the court. The court is willing to do an individualized review later as well. And also, if I did not indicate, a mental health evaluation and following any treatment plans as a condition of bond, since mental health conditions were reported.
So she would be able to leave in order to get that accomplished, I'm guessing, correct, even though it's not a medical emergency. It would need to be a separate, I think, exception to the home confinement.
That would have to be something that pretrial services will be further involved in.
Thank you, Anna.
Thank you. Ms. Ferenczi, any questions?
No, Your Honor, thank you.
The next court date is scheduled for April 15th at 2 p.m. That will be on Zoom. If there is a need for some other review, I'm confident that the parties will raise that by motion.
Yes, Your Honor.
All right. Thank you.
Thank you.
The Oakland County prosecutor says the mother, who is accused of abandoning her 3 children for years, is directly violating court orders. They say Kelli Bryant should have her communication privileges revoked because she's called her children's caregiver multiple times, and that's something the judge said she could not do as she sits in the Oakland County lockup.
So recently, the prosecution filed this motion to ban all forms of communication. So who is the caregiver? Well, according to the defense, that would be Kelli Bryant's own father. And now they're challenging this restriction.
8 times. Oakland County prosecutors say that's how many times Kelli Bryant called the caregiver for 3 children between February 21st and March 7th. Between March 8th and the 12th, reportedly 10 times. The children are at the center of a child abuse case. The Pontiac mother is accused of leaving them to live alone for years. The home's condition described by authorities as deplorable. As part of her bond reduction, she was told to not have contact with the children and caregiver. Now, prosecutors are asking for a judge to revoke her communication privileges. Criminal defense attorney Lillian Diallo is not connected to the case, but says the people's motion is too severe.
And as a defense attorney, I would argue strenuously and vigorously for her being able to have contact, maybe not with the father now. You can cut that off if that's what you feel has been violated, but don't cut off her only means of communicating with the outside world.
In a response, Bryant's lawyer claims neither the mother nor her defense team had been served a written copy of the court's bond order. The defense claims the mom misunderstood the court statement on the record and didn't realize there was a blanket prohibition from speaking to her father. Meanwhile, questions mount surrounding the case.
Somebody needs to say something about how these kids just were languishing for years. No birthday, no Christmas, no Easter. Nobody asked where the kids are.
With new developments in a child abandonment case that's grabbed attention nationwide, prosecutors say Kelli Bryant violated a court order that bans her from contacting her children or their caregiver.
Oakland County prosecutor Karen McDonald is now asking a judge to revoke Bryant's communication privileges.
Well, Bryant allegedly made nearly a dozen calls from jail to try to contact her children. She's barred from doing so. Obviously, now those calls are monitored from the jail. When prosecutor's office found out about it, Karen McDonald filed a motion. She now wants all of Bryant's communication privileges revoked immediately.
If you're in the Oakland County Jail and you have specific rules and provisions and orders, but we have a duty when we know about something and we know that somebody's violating a no contact order, and in this case it's a very serious crime. It's a very serious crime, and we have a duty to protect victims, and we're going to do that every time.
Oakland County prosecutor's office found a motion to revoke all Bryant's communication privileges after learning she violated a court order not to contact her children 10 times. Bryant is charged with 3 counts of first-degree child abuse after being accused of abandoning her 3 children for several years in this trash-filled condo in Pontiac. McDonald says Bryant not only made contact with her children's caregiver directly, Bryant is also accused of having other inmates make calls for her from the Oakland County Jail. Although it's her children she's trying to contact, McDonald says in this case they are the victims.
The evidence shows and suggests, and the allegations are very serious, which is why I'm sure you're all here. It's jarring, and my focus is on these kids, and I don't believe that can be done unless they're in a secure and stable environment with free of influence or pressure from anyone else.
Kelli Bryant in more trouble after allegedly breaking a judge's order to stay away from her kids and their caregiver. Prosecutors say that she's repeatedly not only called the caregiver, but enlisted help from other inmates to make calls as well.
Oakland County prosecutors say that the mom allegedly called a caregiver 8 times between February 21st 21st and March 7th. Between March 8th and the 12th, reportedly 10 times. In a response, Bryant's lawyer claims neither the mother nor her defense team had been served a written copy of the court's bond order. The defense claims the mom misunderstood the court statement on the record and didn't realize there was a blanket prohibition from speaking to the caregiver. And recently we did speak to a legal analyst who believes that revoking communication privileges is too severe. However, this legal analyst went on to say that it is appropriate for her to not have any contact with the children or the caregiver, but to keep the line open to the outside world. However, a judge is expected to decide on what happens next in just a few short hours.
All right, calling People versus Kelli Marie Bryant, case number 250216FY.
Good afternoon, Kelli Bryant on behalf of the people.
And good afternoon, Your Honor. Cecilia Carandago up here on behalf of Kelli Bryant. She's present via Zoom, Your Honor.
Thank you. Ms. Bryant, would you state your name for the record, please?
Kelli Marie Bryant.
Thank you. Ms. Ferenczi, this was People's motion to restrict communication privileges from the jail.
That's correct, Your Honor. As I noted in my motion that was filed last week, the people became aware that defendant had been calling the minor victim's caregiver on a daily basis, sometimes multiple times a day, which is in violation of the custody order that was dated March 7, 2025. I do not believe that defense is contesting the fact that these calls were made. The people do have witnesses on standby if the court does wish to hear testimony. But that is the reason that this motion was filed.
All right, thank you. Ms. Carandago?
Yes, Your Honor, just ever so briefly. So it's my client on the phone call, so that's not really the issue here. The issue that I brought up in my answer, so the people did provide, I want to say about 20 phone calls. There's one single phone call, which was actually prior to the court holding the bond hearing on the 7th. So it was on the 7th in the morning, where the caregiver volunteered some information to Ms. Bryant. Ms. Bryant didn't ask, on none of the phone calls, Ms. Bryant is asking about the children. The issue that we're having is that Ms. Bryant, after the court hearing, so the court held a hearing, made its oral ruling, and then Ms. Bryant nor myself were ever provided with a written order. I don't believe that Ms. Bryant, we weren't provided with a custody order, nor a pretrial release order, nor anything else in writing. Ms. Bryant was under the impression that she was not allowed to talk about the children, inquire about the children, not even ask how they were doing, and she didn't do any of that, Your Honor. Had Ms. Bryant or myself been provided with a written order, I had to go and listen to the hearing again when Ms. Ferenczi called me and indicated that she was filing this motion, because I didn't have recollection of that part of the order. I knew that Ms. Bryant couldn't have contact with the children or ask about them or, try to pass messages or anything like that, and she didn't do that. I did listen to the recording back. I spoke to Ms. Bryant. I emailed the court asking for the order because there was no bond order ever provided to her or myself. I was mailed out a copy that I received a few days ago from the JIS printout, so the register of actions basically that had the bond conditions on them, and I myself provided them to Ms. Bryant yesterday. Neither one of us have still received a custody order or a pretrial release order. And so my position is to revoke all of her privileges at the jail, her communications privileges, with what I believe is a defective notice in writing, and B, she's never engaged in any kind of inquiry or anything in regards to the children. I don't believe it's appropriate. I don't think the people, unless I'm missing something, are disputing the factual statements that I'm making in regards to the content of the phone calls, nor do I think they have any specific knowledge that Ms. Bryant was actually served with any of the orders. So I'm asking, and I'm just going to tell the court, if I had heard the courts, I know exactly what the court said now because I went and listened to it again. If I had known, I would have had a conversation with Ms. Bryant, but I would also have addressed it immediately, because part of the problem is when the court, the court reduced the bond has to be posted somehow. Those were the contents, I want to say, of 95% of the conversations, including the calls that were made by other inmates. Those were only in regards to her bond. So the statements made by the people, and quite frankly, every day in the media since this came about, that Ms. Bryant is somehow reaching out to the children, trying to talk to them, it's just simply not true. So at this time, I'm asking both that the court allow for contact with the caregiver unrelated to the children, which I don't think the people can say that my client ever uttered a word about her children, and at least on the recordings I was was provided, and they monitor those calls, so they know if she talks about the children or if the caregiver talks about the children, which is not the case, that you allow that type of contact with the caregiver because it is the media for her bond issues, but also that you allow her privileges to remain intact. I don't think it's appropriate to revoke them at this time. I did provide her with the order. I don't believe there's been any further reaching out or nothing like that pending the court's decision today.
One thing before I go back to Ms. Ferenczi, it is customary for the court to enter the orders and restrictions from the bench. And the court reviewed them on the record, reviewed them at the time of the hearing, so I don't think there was anything unclear about what the court indicated. But Ms. Ferenczi, any response?
Thank you, Your Honor. I appreciate that. Judge Walker, I agree with that statement. You provided the defendant with actual notice on 3/7/2025. You were very clear in your holding, in your ruling. You stated that there should be no contact, your exact words are no contact with alleged victims, including no personal contact, no reaching out to parties who have control of those children, no contact with them whatsoever. Ms. Bryant had actual notice that day. Your Honor, there is a reason for these no contact orders. As the court is well aware, there are also reasons for bond, which includes the assurance that the defendant appear in court and that the defendant comply with court orders. At best, defendant is skirting the line of compliance here, Your Honor. She didn't understand, she didn't know. That is simply not a defense, especially as she had actual knowledge and actual notice on 3/7/2025 with what the court ruled on the record. Your Honor, my concern is twofold. First, that Ms. Bryant defied the court's order on 3/7/2025 with the no contact, but also is now circumventing Oakland County Jail's rules and having other inmates contact on her behalf, which is in violation of their rules as well. Your Honor, there are multiple reasons for, and I'm not going to belabor the record, the importance of no contact orders. Victim preservation is first and foremost to protect the alleged victims from potential intimidation, harassment, or further harm by the defendant. These victims have gone through trauma and have been going through trauma for years. It only benefits everyone involved to have separation, which is why this court put in place the no contact order with both the victims and also the people that are charged to protect them right now. And I do believe that this is a clear, on its face violation of the custody order that the court put in place on 3/7. And I do believe that the request to revoke these communication privileges is valid, and I ask for the court to do so.
Now, the court has not heard any of these recordings, so I am relying on those who have reviewed them. So, in any of the recordings, has there been any attempt to contact or have conversation with the children?
Your Honor, if I may respond, there has not been any attempt by Ms. Bryant to make direct contact with the victims. There has been one call that I believe Ms. Kirandongo just referenced where there was a discussion about appointments.
And Yana, if I may clarify, the caregiver brought it, they weren't even talking, they were talking about something completely unrelated. The caregiver mentioned that, well, I guess I'm not going to say it on the record. I think the court knows but mentioned an appointment.
Okay. Let me just be clear about one thing, because at the time the court imposed these conditions, the purpose was to protect the integrity of the judicial process, make sure there was no tampering with any witnesses of any sort. And the court at that time did not even know exactly who the caregiver was. But the intention to protect that was to make sure that there was no contact with the victims or anyone who's caring for the alleged victims, so that there is no attempt to influence potential testimony in this case. So that was one of the reasons for that.
Right now, there's been none of that, Your Honor.
Right now, the types of communication that the defendant has is what? Through tablet?
That is my
understanding.
Tablet,
phone.
and
the phone, correct.
Okay. Any other forms of communication?
Not that I'm aware.
Not that I'm aware either.
Is the potential there for the jail to restrict contact to specific phone numbers?
I don't believe so, Your Honor, but I'm going to tell the court if the court she understands now, and if the court is not modifying that, I am telling the court that there's not going to be any other issues. There will not be any other issues. They can monitor her from now until eternity, and she will not violate the court's orders.
I'm not
But I don't think there's an ability
I'm not
to do this.
understanding why other inmates have made calls. That is just baffling to me.
It would explain it on the calls, Your Honor. So Ms. Bryant is housed. First, she was housed in the clinic for a number of weeks, I believe. Then she's housed in a single-man cell. They allow her to exit the cell, I believe, once a day. And the phone calls that were made by other inmates were in regards to the bond. So whether there had been, I think one of them had asked if the caregiver had spoken to another family member of Ms. Bryant's, because it had to do with, where she was going to be when she got out from jail. And all of the other calls were in regards to either reaching out to a bail bondsman, inquiring on whether the caregiver had received a phone number for, a specific bail bondsman. That was the gist of it. Those calls, I think the longest one was 1 minute and 4 seconds. All the other ones were much shorter. There were no discussions about anything else. And the reason it was done, and I don't know, I know you can't do three-way calling. There were no three-way calling. But the reasons that was done is because Ms. Bryant couldn't get out of her cell. And it was after, the court had modified her bond and my client is trying to raise the money to post bond. So there was no discussions either, but that was the reason. And I'm being, as forthcoming I can with the court. It's pretty clear from the phone calls that that's the reason too.
At this point, it appears to me that there was a flagrant violation of the court order. I am confident that you have now reviewed this with her, Ms. Kirandongo, with your client, Ms. Bryant, so there would be no additional such calls. However, the violation is a flagrant one. So I am going to temporarily suspend her jail communication privileges for a period of 1 week because I want to make sure that she understands the court orders are exactly that. They are not suggestions. They are not hopes that you will comply, but I expect strict compliance with the no contact provisions. So I am going to indicate there will be a 1 week suspension of any jail communication. And then, Ms. Ferenczi, if in communication with the jail, there can be follow-up to make sure there are no other violations, because if there is another violation, the court will schedule an emergency hearing within 24 hours of receiving notice of a violation.
Yes, Your Honor, thank you.
Your Honor, is it at all possible, I know the court is a little bit restricted, but is it at all possible to have a bench conference about a separate issue?
I can't do
If
that
it's not,
right
we
now,
can communicate.
simply because we have a 3 co-defendant homicide probable cause conference right after this one.
We'll communicate with the court in writing then,
That's fine.
between Ms. Ferenczi and I. Thank you, Your Honor.
All right, thank you. Bond is otherwise
Thank you, Your Honor.
continued.